Good morning, ladies and gentlemen. The hearing of the Committee on Local Government, joined with the Committee on Peace, Unification and Reconciliation, the Committee on Constitutional Amendments and Revision of Codes of Tuesday, 2015 is called to order. I would like to acknowledge the presence of Senator Chis Escudero and our resource persons who constitute some of the members of the Citizens Peace Council. Precisely today, the agenda today is the report that the Peace Council has prepared for that and has formally handed over to the Senate. You had witnessed it, the press had witnessed it, the handover to the Senate President, and once again in the hearing room just moments ago. So I would like to, for the record, the presence of the different individuals who have, who constitute the membership of the Citizens Peace Council. The former Chief Justice, Jr., Father Joel Tabora, the President of the Ateneo de Davao University, who is representing His Eminence Cardinal Tagle, by Rohanisa Sumdan Usman, the founder of Teach Peace, Build Peace movement, Secretary, the former NEDA Secretary, Secretary Cayetano Paderanga, who represents today Mr. Jaime Augusto Sobel, the Ayala Chairman and CEO of Ayala Corp. Education, and presently the President of the Asian Institute of Management, Secretary Edilberto de Jesus, Professor Moner Bahunay, have I missed anyone? And that is it. Miss Victoria Pena, who is the former PMS head. Welcome to the Senate, ladies and gentlemen. I understand from Chief Justice Davide the presentation that they will be making today has been organized into 4 subjects for which clusters have been organized within the Peace Council. So perhaps I would yield the floor to Chief Justice Davide for maybe an outline as to how you would like to conduct the briefing.
Yes, Mr. Chairman. There will be an opening statement to be delivered on behalf of Cardinal Tagle by Father Tabora. And after that, Cluster 1, chaired by this representation, the report for Cluster 1. Then for Cluster 2 on economy and patrimony, Mr. Jaime Augusto Sobel de Ayala will be represented by Dr. De Jesus. And then, Dr. Paderanga, rather, I'm sorry. Then for the chapter on justice and human development, we will have the youngest member of the Peace Council by man. And finally, Cluster 4, represented by Dr. De Jesus, on behalf of, he was a co-chair of that cluster. So afterwards, we will propose that all of them should first be heard before any interpellation can be made, so it will be a little faster movement. So may I request that Father Tabora be recognized for the opening statement.
Thank you, Chief. Father Tabora, please, for your opening.
Mr. Chairman and Senator Chis. A year ago, our government and the Moro Islamic Liberation Front signed the comprehensive agreement on the Bangsamoro amidst much celebration. The public and the media, we might recall, welcomed the end to war that it promised. Much has happened since then. The group prepared the draft legislation which was awaiting review by Congress. Sadly, the Mama Sapano incident, which cost the lives of combatants and including an 8-year-old girl, reawakened suspicions about the Muslim Filipinos and derailed the peace process. Congress decided to stop its deliberations on the Bangsamoro Basic Law as some members raised questions about the sincerity of the MILF to abandon its insurgency. On March 27th, President Benigno Aquino III invited 5 of us to gather other independent-minded Filipinos to study the Bangsamoro Basic Law to see how we could help clarify the many issues surrounding it. Realizing the importance of the BBL to the peace and development of, as well as to the peace and development of the entire Philippines, we readily accepted the challenge. Although we came from different fields of endeavor, we were united in our desire for peace and believed that we should give its every instrument a chance to prosper. This would require an effort to understand the provisions of the BBL in the context of the history of the insurgency waged by the MILF against the government, and to consider whether this law could effectively address the causes of conflict. We would then give our views on the BBL and help move forward the stalled peace process. Cognizant of our limitations, we invited leaders from various sectors to join us as co-conveners, and they in turn asked others to come forward to undertake an independent evaluation of the BBL provisions. We decided to focus only on contentious issues. We were committed to seeking common ground. 136 Filipinos, Christians, Muslims, indigenous peoples, including religious leaders, civil society representatives, deans of law schools, businessmen, and 3 of the framers of the 1987 Constitution came forward to contribute their knowledge, experience, and wisdom to the discussions. I'm grateful to all of them for their time, their and their goodwill, and have included all their names in an annex to our report. We divided ourselves into and reviewed the BBL along these 4 themes. First, constitutionality, forms and powers of government. Second, economy and patrimony. Third, social justice and human development. And peace and order and human security. We held separate cluster meetings over a span of two weeks and held a 5-hour plenary on April 18th. As Ambassador D described it, the plenary was an avenue for dialogue between and among independent-minded citizens who believe in the importance of understanding the BBL and discussing its implications for peace and development in our country in a calm and reasonable manner. We took time to learn from previous studies and from resource persons who presented views informed by years of studying and attempting to resolve the issues. We recognized some controversial aspects of the draft, but we also shared the view that the legislation for autonomy requires a search for compromise and consensus. The process is the freewheeling exchange of ideas and views, asking hard questions, seeking clarification, engaging in debate and argumentation. Overall, we agreed that the BBL is overwhelmingly acceptable and deserves the support of all Filipinos. On the few provisions that needed some refinement, we offer our recommendations. The BBL seeks to implement the constitutional mandate for autonomy enshrined by the 1987 Constitution. This process began with the good faith effort of the government to establish the autonomous region of Muslim Mindanao. To a large extent, the grant of autonomy within the framework of national sovereignty had prevented conflict from getting out of hand. Clearly, autonomy and peace and development, all constitutional mandates, have become inseparable. We also realize that the BBL will bring benefits that will redound not only to the Bangsamoro, but to all Filipinos. Mindanao holds the nation's untapped but already threatened resources. The potential for development in that region will mean greater productivity for all. The exercise has brought home to us the conviction that the BBL should be passed, that to set it aside now would be imprudent and wasteful of previous efforts. Peacemakers on both sides have spent no less than 17 years to bring us to this juncture. There is enough goodwill on both sides to bring this agreement to its conclusion, one that would and refresh communities in the most deprived regions of the country with a genuine, fresh start. So many eminent public figures, others less known, have given their time to this struggle for peace. They have engaged in dialogue and discussion. He also offered a partnership between his pro-peace group, the Friends for Peace, with the members of the Council, and encouraged us to reach out to other groups with the same objectives: peace and development for all Filipinos. Indeed, we saw our effort only as one of other citizen efforts, and those of government, some larger than our own, whose work has been more arduous, taking longer than our own. We submit our report as our contribution to the search for peace in Mindanao and in our country. We will communicate what we have learned and make available the reading materials we reviewed. We express in the report our support for the passage of the BBL, together with our recommendations on a few provisions. We hope that the Congress and our people can overcome their prejudices. We cannot pursue peace on the basis of mutual fear and distrust. All of us must undertake an active search for justice, truth, respect, love, and peace. We will exert all efforts in disseminating our findings, assuring of the independence of the process. We do so with trust and faith that other citizens like us will decide that the Bangsamoro Basic Law places peace within our grasp, peace for Mindanao and peace for all Filipinos. Thank you, Mr. Chair.
Thank you, Father Tabora, for the opening statement. Perhaps now we can proceed to the first cluster, which is to do with constitutionality. And I think that the former Chief Justice Hilario Davide will be the one who will take us through the points on that subject in the report of the Council. So, Chief Justice, please.
Thank you very much, Mr. Chairman and Honorable Escudero. Shalom. A very peaceful moment for us. Let me further express our profound gratitude to you, Honorable Chairman, for inviting us at the Citizens Peace Council and to hear us on our final report. I was designated Chairman of Cluster 1, which was assigned to study the BBL proposed in Senate Bill 2408 and House Bill number 4994. Focus on the principal issues concerning or relating to constitutionality, form and powers of government, and to plebiscite. The cluster took special note of the fact that the proposed Bangsamoro Basic Law, BBL, which is to fulfill one of the most significant mandates of the 1987 Constitution, is being questioned and threatened with an abrupt end, with contravenes the Constitution. The cluster members conducted a review of the papers, statements presented, and both by those who are opposed to the BBL and those who are defending the BBL. Sifting through the different positions, the cluster then identified key contentious issues that needed to be examined and addressed. The task was difficult and challenging, for both oppositors and supporters had their respective positions with strong arguments. As to Senate Bill number 2408, we have to immediately consider the fact that it is authored and introduced by 13 senators, or a majority of the Senate already, headed by our Senate President Franklin Drilon and the Honorable Senators Soto III, Alan Peter Cayetano, Legarda, Recto Ejercito Bina Escudero, Aquino IV, Angara, Pia Cayetano, Honasa II, and Gingona III. Since all are assumed to be fully convinced that the BBL suffers from no constitutional infirmity, the cluster could have forward closed the chapter, yes, only chapter, of its study. But it could not, for it had before it the counterpart House Bill number 4994, authorized by only 17, headed by the Honorable Speaker Belmonte Jr. of the more than 300 members of the House of Representatives. The cluster had thus to move forward relentlessly up to the end. The Senate also has given the Citizens' Peace Council and its Cluster 1 immeasurable joy. Its report is heard first. It is chaired by a highly respected chairman who is more popularly known throughout the Philippines as Senator Bongbong Marcos. It could be purely serendipity, Mr. Chairman, that the draft BBL, the committee will now deliberate vis-a-vis the report of the Citizens' Peace Council can now have a new historic meaning of transcendental significance. The meaning is Bongbong Law or Bongbong's legacy. Let me now take up my assigned task. Major findings. The cluster's meticulous analysis of the major contentious issues on the BBL in light and on the basis of the interrelated propositions, the framework of the discussions which I shall take led to the following major findings. 1. The BBL does not vest statehood status to the Bangsamoro government. The provisions on people, territory, and self-determination are not vestiges of a separate state, but are consistent with the constitutionally mandated creation of autonomous regions. Second, the Bangsamoro government, parliamentary in form as constituted with the requirements of the Constitution. The government, with an executive department and legislative assembly, has officers that are elective and representative of the constituent political units. Third, the intergovernmental relations between the national government and the Bangsamoro government are consistent with the allocation of powers mandated by the Constitution. The defined relationship between the national government and the Bangsamoro government embodies the essence of genuine autonomy based on principles of subsidiarity. Fourth, the Supreme Court and the constitutional bodies continue to maintain the powers that are given them under the Constitution. There is neither substitution nor diminution of powers intended or affected by the creation of the Bangsamoro Human Rights, Auditing, Civil Service, and Electoral Offices. Fifth, and finally, the plebiscite of the BBL adheres to the provision of the Constitution on the process for creation of the autonomous region. Now, our basis for the findings, which I shall explain in seriatim. There are several objections to BBL provisions on people, territory, and self-determination because of the fear of unwitting creation or recognition of a separate Bangsamoro state. There is no basis for such fear. First, defining a Bangsamoro people does not create a new citizenry or nationality. The definition of Bangsamoro people in the BBL is only an of identity, not a definition of citizenship in the Bangsamoro area. the word peoples is used as a descriptive term with respect to indigenous peoples, the Bangsamoro people, is a part. There does not appear to be any indication of intent to create a new kind of citizen. The non-Bangsamoro do not lose excuse me, civil or political rights, and qualifications for candidacy in the Bangsamoro do not require identification as a Bangsamoro people. Where the term citizen may be interpreted as restrictive, as in the case of the Social Justice Provision, Article 4, Section 7, the term in that case, the BBL provisions describing a Bangsamoro people may stand without need of clarification. Second, defining a Bangsamoro territory does not create or imply an independent state. The word territory, or in ordinary parlance, means generally under a particular jurisdiction. An area which is own defined area, jurisdiction or rules does not make the territory independent from its parent state. It is used to describe trust territories, incorporated and unincorporated territories, occupied territories, non-self-governing territories, dependent territories, or external and internal territories, each with varying degrees of powers and independence and historical antecedents. The Constitution describes provinces, cities, municipalities, and barangays as, open quote, territorial subdivisions, close quote, and describes territories of legislative districts. The Local Government Code frequently refers to the areas of local government units as, open quote, territories, close quote. Article 10, Section 20 of the Constitution speaks of the territorial jurisdiction of the autonomous regions. As with the current Armed Organic Act, there is even a declaration in that the Bangsamoro territory shall remain a part of the Philippines. This is an unequivocal rejection of the idea of statehood. However, as regards the, open quote, opt-in provision, close quote, of contiguous territories, the core Bangsamoro territory should not be allowed to increase indefinitely by the periodic votes of 10% voters in the outer territories. The establishment of a plebiscite that fixes the territory is a congressional prerogative that cannot be delegated. A perpetual opt-in provision makes the Bangsamoro territory indefinite and keeps the Organic Act in constant flux. Since the creation of an autonomous region, including the definition of its territory, is the sole function of Congress, such changes of territory that establishes the limits of the region requires a specific acts of Congress. An indefinite opt-in provision would be an undue delegation of legislative power to a possible erratic 10% of an indeterminate population. For purposes of clarity, it is therefore recommended that the opt-in provisions in Article 3, Section 3, and Article 415, Section 4 be deleted. With the deletions, the definition of the Bangsamoro in the BBL may stand. Third, the right to self-determination is a right of all peoples and is not equivalent to the right to statehood. Its claim and use in the BBL is not a promise of secession, but a declaration of a right all Filipinos possess. The constitutional promise to the Muslim Mindanao and the Cordilleras of their own autonomous region is itself recognition of the need for the peoples identified therein to exercise differently their right to self-determination as part of the larger Philippines. The term self-determination was popularized around the early 20th century when there were increasing moves to decolonize. It is within the era of decolonization that self-determination implied secession. Outside of decolonization, there is no such link. Self-determination is generally understood to mean what our Supreme Court has recognized as internal self-determination. While international the right to self-determination of peoples, there is no right to statehood, and there is no right to secession. As international law encourages peoples to determine their identity, it also frowns upon the destabilization of states and breaches of international peace. that would occur if there was constant internal struggle to secede, and where groups of peoples can be formed based not only on religion but on race or ethnicity or any other criteria. Thus, the BBL provision may stand without need of clarification. The parliamentary form of government for the Bangsamoro is permitted by our Constitution. The prescribed unitary and presidential form of government established in the Constitution refers to the national government. When it comes to the government of autonomous regions, however, the Constitution only requires that it shall consist specifically of the Executive Department and Legislative Assembly, both of which shall be elective and representative of the constituent political units. This is met in the BBL, even though the Minister of the Bangsamoro government is elected by the Bangsamoro Parliament and not directly by the electorate, as there is no requirement in the Constitution that the autonomous region's chief executive be elected by the electorate. In fact, Congress may provide a different government structure within all local government units. The Constitution only requires Congress to open quote, enact a local government code which shall be more responsive and accountable local government structure through a system of decentralization, close quote. What the structure is, open quote, more responsive and accountable is left to the legislature. However, provisions to the parliamentary form of government that need some refinements. One, there is a need to have use of terms. In Article 4, Section 2, the BBL provides that the Bangsamoro government shall be parliamentary. In Section 3 of the same article, however, the BBL uses the term, open quote, on exclusive powers of Article 5 on powers of government. To avoid any confusion and possible misinterpretation, it is recommended that the term ministerial be dropped and replaced with parliamentary, consistently for consistency and clarity. Second, the BBL's Article 7, Section 34 provides for the call for a new parliamentary elections upon a two-thirds vote of no confidence upon members of parliament against the government of the day. While this may be one of the models of the parliamentary form of government, it may mean the holding of elections for the Bangsamoro Parliament every time there is no confidence vote. That is, not later than 120 days from the date of dissolution. This will run counter to the constitutionality mandated synchronization of national and local elections, which, as held in the recent decision in Abbas Kida versus Senate, should include the ARMM elections, as it is a local election based on the wording and structure of the Constitution. To address this, it is recommended that the vote of no confidence must affect the government of the day, not the parliament, so that parliamentary elections in the Bangsamoro can be synchronized with the other national and local elections. In this correction, the issue of separation of church and state may arise. Passing the bill, the BBL, does not constitute establishment of religion, much less enforce one upon Filipino citizens. The creation of an autonomous Muslim Mindanao or the use of Iwali as a titular head at the Bangsamoro does not violate the principle of separation of church and state. Muslim Mindanao is a term used in the Constitution to describe the autonomous region and as a proper recipient of government money, government unit. It is meant to be as descriptive as the term Christian majority is used to describe the rest. The BBL actually secularizes the name Father by using the word Bangsamoro with more emphasis on the historic character than as a religious one. A wali is not required to be a religious person, and as described or defined as much a guardian or head. As it is, our Constitution does not prevent priests from holding public office, only that there are no religious sectors. I will now present the discussion of the cluster on the issues relating to intergovernmental relations between the central government and the Bangsamoro government. The powers of government are classified in the BBL as 1, those that are reserved to the central government; 2, powers that are concurrent between the central government and the Bangsamoro government; And 3, powers that are exclusive or devolved to the Bangsamoro government. This allocation of powers is consistent with the mandate of the Constitution. Recommendations of the caster only pertain to minimal revisions and additional wordings. The grant of to the Bangsamoro is not tantamount to a superior Bangsamoro government or a weakened central government. It only refers to powers that are devolved to the Bangsamoro government, which remains under the central government, but as an autonomous region. To remove such misunderstanding, the title of the section on exclusive powers may be amended to read Section 3, Exclusive and Devolved Powers. This will emphasize that the source of this exclusivity is devolution of powers. The difference with respect to the creation of autonomous regions is the constitutional right to greater delegated powers with to use it, not as compared to government, but as compared to other political subdivisions. Since the Constitution does not allow the creation of any other state or the secession of any peoples, the BBL provisions can imply nothing more than internal organization and creation of the bank as an internal subdivision of the state with designated powers. Congress would have no authority to do anything more. Intergovernmental relations in the BBL refer to the concept of devolution as inspired by the principles of subsidiarity. The President exercises general supervision only over the Bangsamoro government as required by the Constitution. This is clear in the BBL, and there is no provision that indicates a reduced power of the President. Running parallel to the principle of subsidiarity is the principle of solidarity as an inherent right and duty of the state, and not just of the President. As provided in Sections 1 and 6 of Article 12, all areas of economy, whether in the declaration that all economic agents contribute to the common good, where all regions are given the optimum opportunity to develop, or where the private sector is encouraged to broaden the base of ownership and own and operate economic enterprises, these rights are always subject to the duty of the state to promote distributive justice and to intervene when the common good demands. The principle of solidarity is already reflected in section on devolution and subsidiarity, requiring all government decisions to adhere to, open quote, considerations of good government and the general welfare, close quote. Therefore suggested, for greater that Section 6 of Article 6 on devolution and subsidiarity be amended to read principles of devolution and of solidarity, and that all provisions that refer to the principle of subsidiarity, such as in the preamble, should concomitantly include the principle of solidarity. I will now discuss the controversial term asymmetric. Some comments on the BBL equate the asymmetric relationship between the central government and the Bangsamoro government as similar to the associative relationship that was rejected by the Supreme Court in the BBL's predecessor, the MOA Act. A simple perusal of the BBL in relation to the allocation of powers and the intergovernmental relations, as discussed earlier, will clearly demonstrate that asymmetric relationship is different from associative relationship. However, to obviate any doubt as to the meaning of asymmetric relationship, a definition of the term in the BBL may be inserted. The definition will state that the asymmetric relationship refers to the relationship between the central government and the Bangsamoro government as an autonomous region, where, as provided under Section 15, Article 10 of the 1987 Constitution, the autonomous regions are granted more powers and less intervention from the national government than territorial and political subdivisions. The term territorial and political subdivisions refers to other local government units. This is a combination of the definition proposed by Dean Antonio G.M. Lavinia and the description provided by Justice Marvic Lunan in his concurring opinion in the case of League of Provinces of the Philippines versus DNR. The enumeration of powers given to the Bangsamoro Parliament under the BBL is consistent with the constitutional provision. Article 10, Section 20 of the Constitution is broad enough as it includes a paragraph on such other matters as may be authorized by law for the promotion of the general welfare of the people of the region. The potential overlap between the legislative powers of the Congress and the Bangsamoro Parliament, which is objected to by some experts, is an unavoidable consequence that is also true as far as the legislative powers of regular local governments are concerned. These potential overlaps or even conflicts should be addressed with the application of the principles on hierarchy of law and conflict of laws. The grant to the Bangsamoro government of the authority, power, and right to explore, develop, and utilize the natural resources of territorial jurisdiction is an acceptable formulation. However, it is proposed that such authorization given to the Bangsamoro government must be understood as subject to the provisions of the Constitution on national economy and patrimony. As regards the fiscal autonomy provisions, we do not find any constitutional infirmity in the provisions of the BBL. The block grant is not akin to the PDAF, declared unconstitutional by the Supreme Court. The block grant referred to in the BBL is similar to the Internal Revenue Allotment, or IRA, under the Local Government Code. In fact, the wording of BBL's Article 12, Section 15 to number 17 is very similar to the Local Government's Code's formula in Section 284 and 286. Similar to the provisions concerning the IRA for ordinary local governments, the block grant for the autonomous region is a faithful adherence to the constitutional mandate that local governments shall have a just share and by law in the national taxes, which shall be automatically released to them. On the cluster also reviewed the BBL provisions relating thereto. The BBL Section 3 of Article 10 provides for the power of the Bangsamoro Parliament to enact laws pertaining to, open quote, persons and family relations, and other civil law matters, commercial law, criminal law, including the definition of crimes and prescription of penalties thereof, close quote. This provision is within the powers of the legislature to delegate to local governments as provided for in Article 6, Section 1 of the Constitution. The restrictive wording in the Constitution's Article 10, Section 18, and Section 20, Paragraph 4, which provides that legislative powers of the autonomous region may only extend to personal, property, and family relations. Section 20, Paragraph 9 also states that the organic tax shall provide for legislative powers over such other matters as may be authorized by law for the promotion of the general welfare of the people of the region. Article 10, Sections 5, 6, and 7 of the BBL provides for the establishment of Sharia circuit courts, Sharia district courts, and a Sharia high court, respectively. These provisions are within the power of Congress to define and expand jurisdiction of courts. Under the Constitution, the Congress shall have the power to define, prescribe, and apportion the jurisdiction of the various courts. Article 8, Section 2. Hence, this legislation can be included in the additional matters that the Congress can authorize the autonomous regions to possess. Furthermore, it should be clarified that judicial authority is not being granted the Bangsamoro government. It must be noted that in BBL's Article 7 on the Bangsamoro government, there is a set of provisions on the Parliament and a set of provisions on the executive officers, but none on the judiciary. Judicial power remains with the Supreme Court, which is vested by the Constitution, which Article 7, 8, Section 1 of the Constitution. The BBL envisions the creation of the Sharia law, it should be called, with application over Muslim only, the traditional or tribal system for the indigenous peoples in the Bangsamoro, the local courts, and the alternative dispute resolution systems. The BBL's provision in Article 10, Section 7 may be seen constitutional for apparently limiting the jurisdiction of the Supreme Court provided under Section 5, Article 8 of the Constitution, which jurisdiction Congress may not amend under Section 2 of Article 8. The provision states that the decisions of the Sharia High Court shall be final and executory. This is not unique to the BBL. The Labor Code, as an example, is replete with provisions making decisions of the Secretary, the National Labor Relations Commission, and the voluntary arbitrator final and executory. Despite this wording, however, the Supreme Court has consistently ruled that such decisions shall still be subject to the review powers of the Supreme Court. In order to avert any confusion, the provision may be amended to include the clause subject to the review powers of the Supreme Court. Now on the constitutional bodies. The BBL introduces the creation of the following bodies: Bangsamoro Human Rights Commission, Bangsamoro Auditing Body, Bangsamoro Civil Service Office, and the Bangsamoro Electoral Office. The validity of the provisions of these bodies is being questioned on the main ground that their creation and the power vested in them under the BBL are unconstitutional, as they and expand the powers vested in the national constitutional bodies. The reference to the Human Rights Commission, Auditing Body, and Civil Service as constitutional bodies is inaccurate and may be misleading. They can be distinguished from other offices, which the Bangsamoro government may later establish, the BBL. They derive their basis of existence not from any ordinary law that may be promulgated by the Bangsamoro Parliament, but from the Organic Act itself. This does not mean, however, that they are constitutional bodies in the sense that they can adversely affect the roles, mandates, and powers of the constitutional bodies established by the Constitution, COA, Civil Service Commission, and Commission on Human Rights. The wording of the BBL is clear. The Bangsamoro special bodies were created with the goal of supplementing, not supplanting, the work of their national counterparts. As such, sections which may provide for the creation of these Bangsamoro bodies include the clause, open quote, without prejudice to the powers, authorities, and duties, close quote, of the National Constitution for the and the Auditing Office, and the clause shall have a coordination and complementary relationship for the Human Rights Commission. The way that the BBL is structured will show that the powers exercised by the Bangsamoro special bodies are not exclusive powers, but concurrent powers meant to be exercised in a coordinated and complementary manner with the national constitution and without prejudice to the constitutional bodies exercise of the respective mandates and powers under the Constitution. However, the comment of the Commission on Audit on the issue is enlightening. In COA's position paper, it was recommended that the Bangsamoro Auditing Office could only mean or refer to an internal body or office, an internal auditor in the nature of and within the functions provided in Republic Act number 3456 as amended by the Republic Act 4177, otherwise known as the Internal Auditing Act. This means that the Bangsamoro government is not precluded from creating a special body like an auditing office, as it will be considered as an internal body, which will not in any way prevent or obstruct the functions and powers of the COA. The Bangsamoro Electoral Office is distinct, for there is a categorical provision saying that it shall be part of the Commission on Elections. In fact, even its budget is part of the appropriations of the COMELEC. Thus, the Electoral Office is not among the concurrent powers, as the evident intent is for the Bangsamoro not to have its own election office, leaving these functions solely with the national government. It is therefore recommended the last sentence of Article 5, Section 2, Paragraph 8 of the BBL, which reads, the Bangsamoro government shall have primary disciplinary authority over its own officials and employees, the clause, open quote, without prejudice to the powers of the Civil Service Commission and the Ombudsman, close quote, be added to address the concern that such section diminishes the Ombudsman's mandate or over public officials and employees. I shall now take up the issue of plebiscite. For the establishment of the Bangsamoro and the determination of the barangay territory to take effect, the BBL requires the ratification of the BBL itself by majority of the votes cast in the plebiscite in the geographical areas enumerated therein. This plebiscite adheres to the constitutional provision on the process for creation of the autonomous region. The Constitution is saying that the creation of the autonomous region shall be effective when by majority of the votes cast by the constituent units in the plebiscite called for the purpose. Article 10, Section 18. Section 3, Paragraph E of BBL's Article 15 provides for the opt-in of contiguous areas where there is a resolution of the local government unit or 10% of the registered voters in the geographical area for their inclusion, and majority of the registered voters vote for their area's inclusion in a plebiscite called for that purpose. This must be the Section 4 of the same article, which was discussed earlier in relation to territory. Section 3E refers to the inclusion of contiguous areas in the plebiscite for the approval of the BBL, while Section 4 applies to the additional contiguous areas after the ratification of the BBL. For your honor's information, one of the annexes to the final report of the Citizens Peace Council contains just that amendments or refinements to affected provisions of the BBL. After our discussions of the cluster's major findings and the basis thereof, allow me now to briefly present the overall framework that guided the cluster in its review of the BBL. The cluster's analysis of the BBL is premised on 5 interrelated propositions that serve as the overarching framework for the cluster's task. First, the law that creates an autonomous region is a constitutional mandate. Second, the passage of an organic law for the autonomous region is compelled by the imperative of correcting the injustice, the urgency of the socio-economic political context at present, and the uncertainty of having a similar opportunity in the future. Autonomy, especially in the context of the Constitution's mandate for the creation of autonomous regions, is in itself a peculiarity, and the region that is given autonomy must be recognized and respected for its uniqueness. Fourth, the BBL must be understood as an extraordinarily special law, not only because of its nature as an organic act, but also, and more importantly, as an embodiment of a peace agreement, the product of prolonged negotiations. Fifth, the Constitution must be interpreted liberally so as to give life to its provisions, fulfillment of the decades-old mandate for genuine regional autonomy. Unlike ordinary legislation, the BBL is not merely a part of the regular exercise of the state's legislative powers. It is the performance of a sacred constitutional duty. Viewed differently, as the eminent constitutionalist Bernas would put it, the establishment of the autonomous regions is not a question of privilege, but a question of right for the regions that were guaranteed autonomy. The statement of the 14 surviving members of the 1986 Constitutional Commission, myself included, aptly characterized the realization of the constitutional promise as, open quote, closing the gap between law and justice, close quote. The negotiations for the Bangsamoro peace agreement have dragged on for 17 years. The result is an autonomous law that broadens the original one and more fully complies with our government's constitutional promise and duty. With the Aquino government's commitment and the trust that it has among the Bangsamoro people, the current context provides an auspicious timing for the creation of the Bangsamoro region. And with the first approaching election and the upcoming transition in government, further delay in the completion of the process could effectively derail the peace agreement. Autonomy and self-governments are not equivalent to independence or statehood. It is a statement of national unity achieved not just by acknowledging human diversity, but allowing diversity to thrive. The autonomous regions were created as special governments that were distinct from the territorial and political subdivisions existing prior to the 1997 Constitution. The specific provisions on the autonomous regions are not just token statements about internally diverse histories and cultures of the Philippines. They are a recognition that, despite decades of trying, these different cultures had not been served in any effective way by the national government. The Constitution therefore contemplates the single democratic and republican Philippine state. Congress would create autonomous regions that could exercise all traditional powers of government, police power, taxation, and eminent domain in the same way as all local government units, but would enjoy interference from the national government. This flexibility and freedom given to the autonomous regions is the only way they could successfully chart their own unique path. Parenthetically, the creation of such a sub generis autonomous region in Muslim Mindanao can be considered as a pilot case and model for the future development of the rest of the country, including revisiting the effectiveness of the unitary system. The BBL must be understood in its proper context. It is not an ordinary legislative proposal that comes into being merely with the sponsorship of a legislator or a group of legislators. It is likewise not comparable to a number of the proposals that came out of a process of drafting by stakeholders and eventually picked up by champions among the legislators. The BBL is a product of a peace agreement forged after decades-old peace negotiations born out of the country's exhaustion with war. The negotiations were done with the participation of international facilitators and observers. The drafting of the BBL underwent a process, even necessitating the creation of a composite Bangsamoro Transition Commission. This does not mean, however, that the Congress, as the repository of legislative powers, is deprived of the exercise of its constitutional prerogative. On the contrary, understanding the nature of the BBL will place greater significance on the legislative progress and put it in the proper perspective. In interpreting the BBL, any doubt may be construed liberally and not restrictively, so as to give life to the constitutional mandates. The BBL does not guide the interpretation of the Constitution. The Constitution guides the interpretation of the BBL. Much of the confusion concerning about the functionality of the BBL can be resolved by applying one of the most basic rules of interpretation in constitutional law. As the fundamental, paramount, and supreme law of the nation, the Constitution is written in every statute and contract. As a rule of statutory construction, if there are provisions of a statute irreconcilable with the Constitution prevails. When reading the Bangsamoro Basic Law, it is therefore presumed that all constitutional powers of government, the constitutional commissions and bodies remain intact, regardless of whether the law explicitly provides for it or not. There is no creation of a separate kind of citizen, and no creation, virtual or otherwise, of a political territory that is greater than the national government that creates it, or beyond the reach that allows it. There can be no surreptitious amendment of the Constitution because even if it is the intention, there can be no interpretation of the statute that could. In sum, the BBL complies with the Constitution's mandate for the creation of autonomous regions within the framework of the Constitution and the national sovereignty, as well as territorial integrity of the Republic of the Philippines. While imperfect, it is a significant document that should serve as catalyst for building national consensus towards the realization of the long-term aspiration of the country 3 decades ago for justice, solidarity, and peace for Mindanao and the entire Philippines. But I wish to end by emphasizing a very important point. In the separate meetings and in the plenary meeting on April 18, the issue of social justice and human development took a very prominent role in the discussions. It came out as a common concern. Indeed, it was a unifying theme for the 4 clusters. So as the country eagerly awaits the actions of the policymakers on this important legislation, I must emphasize that the BBL is not just about the grant. It should not be seen as merely a division of powers, resources, or responsibilities between the national government and autonomous region. The BBL should be understood for what it really is, an instrument to pursue social justice and development for the constituents of the autonomous region, for the entire Mindanao, and for the country in general. The BBL is a path to peace. Doubtless, it will not solve all the problems of the country or of the autonomous region. But it is a foundational element of a necessary first step without which many worthy initiatives cannot even be tried. There is no guarantee of success, as no constitutional law or government can make such a guarantee. But it is a moment for opportunities for a new beginning, to correct the mistakes of the past, to craft a better future. We have all lost so much in waging war against each other for so long. Now is the time for the country to try to win by being united in pursuing justice, peace, and development. Thank you very much, Your Honor, for the time.
Thank you, Davide. We will, as promised, proceed with the next presentation. Just to make we make the observation, as you were making your presentation, Chief, that there are significant divergences between the interpretation that you have put forward and that of the OPAP and the MILF, and for that matter, the Executive Department. So perhaps those are the areas which we will have to put the committee in a bit of a quandary, because we have to now resolve those significant divergences, as I've mentioned them. But thank you for your inputs.
Mr. Chairman, on
Senator
that point
Escudero.
precisely, on those 2 points. Una po, Chief Justice, salamat po sa inyong presentasyon. Hindi ako napakinggan ng unang beses ko palang napakinggan na kung OPAP lang sana o MILF po ang nagsabi niyan, malayong mas maganda siguro naging diskusyon kaugnay. I asked this question. So therefore, the position of the peace panel is this: BBL as amended, not BBL as is. BBL is constitutional if it is amended via the perfect that you presented. Would that be a correct statement? Sir, the mic.
Our concentration was not on the BBL itself as constitutional or unconstitutional. Certain provisions which had been felt to be unconstitutional. It would only be this part that should be affected. So, okay. And then we made recommendations. It would be very, very clear from our recommendations that unless we do something about these areas of concern and some refinements would be done, then the issue may remain. So hence our proposal that probably we could improve and therefore submit one which would really comply with the Constitution.
You are more diplomatic than I am, Mr. Chief Justice, but the long and short of it, not as is. You are in favor of the contentious provisions of the BBL that you discussed, but not as is. It needs refinements.
The entire, as I said.
Not the entire, just
Yes,
those that
only
we looked
those
at.
portions.
Yes.
Because we cannot simply declare the entire thing as unconstitutional when only a few
Definitely.
are found to be violative of the Constitution or perceived to be violative of the Constitution.
I only raised that point, Mr. Chief Justice, distinguished members of the panel, because that has been the mantra of both the OPAP, the MILF, and the executive branch, including Malacanang. As is, where is. I'm glad that we cleared that out, that even the peace panel is not suggesting an as is. That is as kind as I can be to them, Mr. Chief Justice. And second, as the former Chief Justice, sir, as Senator Marcos said, ano po ba ang kinalaman nito sa buong usapin kaugnay ng BBL at pagpasa nito? Sabi nga po niya, iba ang sinasabi ninyo, mas magalang, mas mabait, mas maliwanag, sa sinasabi po ng OPAP at MILF na siyang nagbalangkas, sumulat at naghubog nitong BBL na ito. Kung titingnan po natin sa perspektiba ng batas, ang titingnan, intent ng Kongreso. Base sa mga nagsulat nito, maliwanag ko na hindi kami nagsulat nito. Alam naman ho ng buong bansa na nagsulat nito sa ng MILF at ng OPAP at ng GRP. Iba ho yung korte at maaaring iba ang pananaw ng korte kaugnay sa constitutionality ng ilang mga probisyon. May I ask, Mr. Chief Justice, what relation, if any, does the opinion or do your opinions have, and that of the peace panel as well, to the BBL that we will be passing? Ito ba'y may persuasive effect sa interpretasyong ibibigay namin dito o sa ibibigay ng Korte Suprema pagdating ng panahon? Because, for example, I've heard former CONCOM members expressing their opinions about the BBL, but that was never discussed in the CONCOM debates. Anything they say today, even if they were a former CONCOM delegate, has no relation to the BBL because they did not discuss that when they did Article 10, Sections 15 to 21 of the Constitution. So that's a bit unfair, to say the least. When they are speaking as a former CONCON member and saying this is constitutional, this is not, when that was not even in the deliberation. So, in light of that, by analogy, what relation to this have, if any? Because I am comforted by a lot of the statements you said. As in, marami ho sa ating mga kababayan na makakatulog sa lahat ng sinabi ninyo o sa interpretasyon o sa pagbabal. Subalit, ano ho bang kinalaman yan kung meron man sa aktual na magiging interpretasyon ng BBL dahil iba nga po ang pananaw ng GRP at MIA, sabi ninyo eh. Best example of which would be the constitutional bodies. Ang sagot ho sa amin ng OPAP at GRP, regional offices lang ito. If these are regional offices, then we don't even have to provide for it. We can remove it altogether. But your interpretation is more sound, actually more rational and reasonable, and I do not know now where to place that in relation to what has been told us by OPAP, GRP, and MILF. Kindly help us sort through it, Mr. Chief Justice.
Well, yes, I think that before we enter into the discussion, because the time is an element here, I think it is maliwanag na between the members of the committee that we find ourselves now in that quandary. What is the context in which we apply the recommendations that are being made? At least, sangayon ako kay Senator Escudero, kung mga suggestion ninyo tungkol lalo na sa constitutionality, dahil ang aming laging naririnig noon, galing sa OPAP, galing sa MILF, galing sa Executive Department, ay kahit isang tuldok ay hindi dapat palitan doon sa draft BBL. Ngayon, sa inyo ay nanggagaling ang mga rekomendasyon na mga pagbabago, mga amendment. At kaya't we have, that is why we are now presented with different, very, as I said, fundamental and significant differences between the interpretation of the Peace Council and of those who were involved in writing the BBL. So, the draft BBL. So that is the situation we find ourselves in. And you will have to help us as we go along this process kung paano nga natin i-resolve ba yung ganyang klaseng sitwasyon. So, as I said, before we enter into the lengthy discussion on this, unless you would like to respond, I would suggest we move on to the next cluster.
Just very briefly.
Yeah.
I might lose track along the way later on if I have to wait. First, the BBL was never taken into consideration during the 1986 CONCOM. It's very obvious, no? But we talk already about autonomous regions. And therefore, it can be made applicable to any other organic act. So, in short, the constitutional basis for the BBL is that particular provision on the autonomous region. So, only the principles there must guide us. Secondly, the committee may have heard so many opinions already. Ours is only a little contribution. So, in the end, the final arbiter would be Congress of the Philippines. And to you, to the we commend to you our recommendation, subject to the collective wisdom initially of the committee and then later on of the Senate. So this is the rare, distinct opportunity really to be able to hear many sides and to come up later on with the best compromise that you can have to attain the objectives of the BBL.
Thank you, Chief, for that explanation and clarification. I guess.
Just, forgive me, just a brief rejoinder. Actually, Mr. Chief Justice, ang hinihiling ko po, paano po ang gagawin namin para maging bahagi at parte ng formal na maliban sa aktual na pag-effect po ng mga amendments na sinasuggest niyo. Kasi nga, gaya na nasabi ko, mas maganda ho kayong pakinggan kaysa yung OPAP at GRP. Sa totoo lang, mas tama ho yung simula nyo kanina, yung Shalom eh. Sa bago ho kayo nagsimula. How can we make as an integral part the comments of the peace panel thus far made insofar as Congress's interpretation or how the courts will interpret this that we will be passing upon, either in its current form or in another form?
Honors that the committee executive session and probably we will take up article by article of the proposed BBL. And I think that would be the most appropriate time when you can reflect on the various ideas coming from the various sectors. So, in the end, what will come out really would, which will not require even interpretation at once. A basic law that will require only application yet. The interpretation will come later on. Some questions regarding constitutionality. But I think even on that particular aspect of constitutionality, you have to apply the rule of statutory construction, and if it is only by showing up great, clear, certain unconstitutionality that it may be. If there is any doubt, constitutionality.
Ideally, the questions on constitutionality, we would have time. The final version will be discussed and finally passed by the Senate. So that is the process that we are hoping, within which we are hoping to achieve that. So again, thank you for your presentation, Chief Justice Davide. On to the economy and patrimony cluster, and I believe Secretary Paderanga will be the one who will make that presentation. So Secretary, proceed.
Thank you very much, Your Honor, Mr. Chairman, and good morning to all the members of the panel, members. And following the lead of Chief Justice Davide, let me greet you all. Salam alaikum. I am representing Mr. Sobel de Ayala, Your Honors, who sends his regrets because he had to be out of the country at this time. We, towards the end of, during the part of the presentation, Your Honors, essentially many of the points will be put in a tabular manner so that for ease, for clarity and also for economy. In this study, the objective was to review drafts of the BBL's Article 13 on economy and patrimony and to identify, discuss potential issues that the process was the review of resource materials, among others, the Bangsamoro Plan, which actually turned out I say that as a former head of the planning agency of the government. Working papers and presentations from organizations such as the Philippine Center for Islam and Democracy, PCID, and the Foundation for Economic Freedom, FEF. The cluster also consulted key resource persons. So in the end, the discussion group actually was relatively highly qualified and also a bit large with contributions from everybody, Your Honors. The first, there were some key observations that we thought might be important to remember. One, the majority of the potential economy and patrimony-related issues the BBL are not major and may be resolved further by further clarification as the BBL is written. Second, the devolution of laws is actually already happening. In other words, issues that have been raised are essentially non-issues because these are already being done under present laws. And that would probably become clear. Third, peace and order. Security is the key issue of potential contention. These are provisions. And finally, Your Honors, the cluster deemed it important to mention that the BBL is an opportunity to have a historic change rather than a problem. The relevant plenary discussions, Your Honors. First, the private sector is keenly watching how BBL and the eventual establishment of the Bangsamoro government will affect the investment environment and economic growth of the region. In the meetings on Bangsamoro that was organized essentially, Your Honor, FEF and the Philippine Center for Islam and Democracy, the private sector were very strong participants of the meetings, showing their intense interest on how they could participate in the development of this particular region. Second, opportunities in the Bangsamoro should be highlighted, not only for the business sector, but also for consumers, all of them, including Muslims, Christians, and Lumads alike. It is also useful to underscore positive aspects of having a Bangsamoro government. For example, the attraction of new markets, ASEAN as in majority Islamic market, including also the Middle Eastern countries. If, in fact, there's very strong Bangsamoro or presentation, then, in fact, these markets will become much more open to Philippine products. And I think with partnership between national government and Bangsamoro government, the economic identity of us joining markets like this will actually be highlighted. The Bangsamoro government could be a model for ASEAN on regional autonomy, especially for countries like Thailand and Myanmar, where there are significant minorities, in fact, Muslim minorities, both of whom are facing similar secessionist challenges. The Bangsamoro region creates possibility of exploitation and the mitigation of inequitable distribution of economic benefits. Social justice may be a useful guiding principle of BBL in relation to the natural resource management, especially in areas under stewardship by marginalized groups. The belief of the cluster, in fact, Your Honor, that there might actually be principles that are inherent or in the essence of Philippine ethnic groupings that are actually quite attuned to the natural resource endowments of this country. Proper stewardship of environment which hinges on governance and leadership of future Bangsamoro government. BBL presents the opportunity to do it right from the start, with help, of course, potentially from the business sector. This may include the right of common good under concurrent powers, Article 5, Section 2, along with intergenerational responsibility to care for the environment. Investments will still have its own set of risks, which is true of all investments, and not necessarily attributable to BBL. We present in tabular form, Your Honors, some of the potential issues and the views, the consensus views of the cluster during the discussions. First, on natural resources. The Bangsamoro government will have exclusive powers on ancestral domain and natural resources, including mining. How will this affect the private sector's ability to invest in related sectors? It turns out, upon discussion with some of the that devolution is already happening. For example, certain DNR authorities are already devolved to local governments, including the ARS. Second, labor matters. The Bangsamoro government may organize its own social security and pension systems. New laws on labor and employment, applicable only in Bangsamoro, there will be uncertainty for businesses. The cluster view, Your Honors, was that armed dole already has a degree of independence, but actually needs clarity on how deviations may be legislated by Bangsamoro. Any wage disparities between the Bangsamoro region and the rest of the country actually will be managed by the local wage boards in coordination with relevant national agencies. In other words, Your Honors, there are actually already, third issue is land transfer. Land registration will be aligned with central government, but land acquisitions and transfer shall be governed by the Bangsamoro government and may or may not be consistent with the rest of the country. The cluster view is that the land titles already registered under the national system will be honored by the Bangsamoro government as well. There may even be an opportunity to streamline land management and administration in Bangsamoro, which, if found to be quite useful, may actually be replicated in other areas. As it turns out, Your Honor, it seems that there are actually several authorities and several layers where there is potential overlapping, but the reorganization of the government that may come out may actually give us the opportunity to streamline the process. 4, in customs and tariff, the enforcement of customs and tariff laws to be done through intergovernmental relations mechanism between the Bangsamoro and central governments. The fear has been that this may promote more smuggling in the region. This may require more clarification on the manner of enforcement. On the other hand, Your Honors, ASEAN tariffs are already at 0, except for rice, sugar, and a few other items. Smuggling to avoid VAT is a temptation, but is not unique to the Bangsamoro region. VAT impact for imported goods for resale may actually be quite limited. And infrastructure. It's not clear whether central government's infrastructure development programs, for example, the PPP program, will apply to Bangsamoro. Infrastructure investors may need more clarity on this. This, I think, was the private sector representatives. The cluster view, Your Honor, was that BDA, the development, which is their equivalent of the Economic and Development Authority, is actually close to finalizing the Bangsamoro Development Plan, which presents detailed budgets that can form the basis for the selection of possible PPP infrastructure projects. And actually, the Bangsamoro Development Plan provides very good and clear directions that can already be looked at. On the power sector, the Bangsamoro government shall regulate generation, transmission, and distribution when not connected to the national grid. Otherwise, the Bangsamoro government shall coordinate through the intergovernmental mechanism. The cluster view, Your Honors, was that this may need further clarification to develop and disclose the parameters managing power projects connected to the national grid in coordination with the central government. Such parameters should be developed in coordination with the Mindanao private sector. On transportation and communication, the Bangsamoro government with DOTC, the Construction Industry Association, the CAB, the MIA, the PPA, Philippine Ports Authority, LTFRB, LTO, and the NTC shall exercise of additional powers in transportation and communication. Why is there special treatment for the Bangsamoro government on this? The cluster view, Your Honor, was that the Bangsamoro government will need to work closely with these agencies to determine any additional powers and the extent of check and balance mechanisms. On the power to take over a business, the Chief Minister may order the temporary takeover direct operation of any privately owned public utility or business affected with public interest in times of state of calamity. The private sector, the cluster view, especially the private sector, Your Honors, needs clarification to a specific set of instances. In fact, businesses can be taken over by the Chief Minister. On taxes, the Bangsamoro government, through the Bangsamoro Tax Office, shall have power to enact its own. Business community is uncertain of businesses will be taxed under this new tax regime. The cluster view was that this need not be an issue. Major taxes in Bangsamoro are the same as national tax, VAT, excise taxes. Devolved taxes to the Bangsamoro are minor in nature and will still require coordination with the central government. Taxes may actually be set lower in the region to promote investment. Inland waters. The Bangsamoro government shall have exclusive powers over inland waters and may enact laws on the regulation, management, and protection of the resources therein. There is uncertainty how this will affect the power of the central government. The cluster view was that this needs further clarification to ensure access to water remains equitable. The issue of the block grant, Your Honors, the state should provide an annual block grant to Bangsamoro representing its share in the national internal revenue of the Philippine government. Public perception is that the Bangsamoro is receiving more than its due share of the national internal revenue. Upon examination, Your Honors, the cluster view is that more details on the amounts to be received by the Bangsamoro government's formula could actually address this perception. It was actually stressed that amount will be reduced by future tax revenues. Incremental cost to the national government amounts roughly to about 10.5 billion pesos. The rest, Your Honors, that have been mentioned in the block grant is already part of the existing annual ARMM appropriations. On the potential auditing, on the auditing body, the public perception is that the Bangsamoro will have its own audit commission independent of the COA. the cluster view, the economic cluster, Your Honor, is that this need not be a contentious issue, but more of a misinterpretation. If any is necessary, and we have heard Chief Justice Davide already expound at Your Honor, if any rewarding is necessary to avoid misinterpretation, the provision in the comprehensive agreement on the Bangsamoro may be considered. The Bangsamoro audit body will still be subject to governance by the COA. On security, peace and order also affects the growth of businesses in the area. In Bangsamoro, security and maintenance of peace and order rests on the Bangsamoro Police, which shall be part of the PNP, but governed by a different law enacted by the Bangsamoro Parliament. Will this structure work? Was the question raised. This is an important economic issue in the cluster's view, Your Honors. The bulk of the Bangsamoro Police Force will come from the existing body. The Bangsamoro Police Force is still an NAPOLCOM. The Chief Minister, as head of the Police Board, it makes sense to provide power over security uses on police use in other areas. The PNP chief, however, still prevails agreement. We note that investment insurance schemes from NIGA, ADB can help also address this issue as well. To the security or certainty of investments in the area. The provide a letter explicitly by the by the peace, economy, and treatment. Thank you very much, Your Honors, for this opportunity to address.
Thank you, Secretary Paderanga. The is that mostly, especially on the areas of in this cluster, patrimony, still many areas that have been in different ways. In that sense, we agree with your assessment of so there are certain which have been questions, and I think feel that we'll need more than clarification of definition of terms. The actual print are being adopted. We can again. I don't want to go into detail. I think the sectors that these areas that you mentioned, there is very much the question that's why the intent of the Bangsamoro government and the Bangsamoro of other local comes through the share of national wealth. On the police area, this issue is again power sharing between the national government and Bangsamoro government. And the tendency, I think, of our discussion has been going towards making it a more equal, putting the agencies and powers to be put on our to the other local government. The problem being that we do not have a government unit, and that we are actually redefining, or not redefining, never have defined, are merely administrative in nature, and they have been created as such. Again, this is what we in Congress to make. So thank you.
Mr. Chairman, just this may mga provision. Wala pong konkretong pantalang amendment kung paano po lumiwanag sa punto de vista ng mga negosyante. We note that you only mentioned that provision needs further amplification. Do you have suggested amendments already insofar as the that are concerned?
Yes, Your Honor. Well, in most of these cases, the references that were Honor actually ways of addressing these issues, but in some cases, this really has been raised. I think the features of the economy and was that cluster itself, including the previous conferences that on the Bangsamoro government held essentially by BCID and nation freedom, already a lot of input from the private sector, both the private sector for a region and the private sector, and their concerns. And so, in a way, this has been brought to your part of the evaluation. The to give solution to some of that, and this under available to help out.
Mr. Chairman, just one brief point. Isang halimbawa po, Secretary Padilla. Sabi niyo po, wala naman talaga. Actually, may binabago na BBL as local government units are concerned in the right direction. I would agree. May bill.
Been defined. The other point that I would like to raise, because we speak on the patrimony Bangsamoro waters and its effect on our claim on Sabah. This has been raised by the Sultanate of Sabah, and it is something that needs to be attended to, because the is made by the Sultanate point to the Sultanate and to the country. So again, that is something that I think the reason you did not specifically address it is that it cuts across the different subjects as defined. So perhaps that is something that we can look further in greater detail. Be given us by Rohanisa Usman. So,
A peaceful
please.
noon, Mr. Chairman
Good
and Scudero. Assalamu alaikum wa rahmatullahi wa barakatuh. May peace and mercy be upon us all. What I'm about to present to you is a report on social justice and human development. In one of the commentaries historical antiquity conducted by Ms. Heidi Gloria of the problem discrimination, deprivation, neglect, and plain indifference to the Muslims and other indigenous Mindanao is supports the core principles principle of the 1997 need for some refinement and fine-tuning of certain provisions. There are special concerns raised with regard to the indigenous peoples, the katutubo of Muslim Mindanao. We invited tribal leaders representing non-Moro indigenous peoples communities in Muslim Mindanao affected by the BBL to join the deliberations on indigenous peoples' rights, and they are of one wanting to ascertain that their rights under the Indigenous Peoples' Rights Act, RA 8371, and other laws are reasserted, recognized, and protected under the BBL. We support them in this regard. Therefore, we propose a number of amendments to provisions pertaining to indigenous peoples. With this mentioned premise, we wholeheartedly endorse the BBL and recommend its passage as an act of justice and reparation to the Bangsamoro peoples now to rectify all the injustices inflicted upon them in the past. It is our hope that the Bangsamoro will serve as a model for the rest of the country in fulfilling the 1987 Philippine Constitution's mandate to secure social justice to the Filipino people. The BBL in Section 5 of Article 7 has provided a venue for genuine representation in the Bangsamoro Parliament by reserving seats for sectors on the margins that would otherwise not have the opportunity to be heard. While the cluster sees this provision as a positive component of the BBL, expanding the number of reserved seats is recommended. We affirm that these give politically marginalized...
I'm sorry,
Yes.
it's not the question, it's just to clarify.
Yeah.
Reserved seats for the IPs? Is that what you were
I'm
referring-
about to,
okay.
I'm about to
Yeah.
continue.
Sorry for the
It's okay, it's okay. We affirm that these give politically marginalized sectors of Moro territory the opportunity for genuine representation in its body. Without prescribing exact numbers, we feel that the non-Moro indigenous peoples, which they were very strong about it, and women need more seats to represent the multifarious concerns pertaining to women. And as for non-Moro IPs, several major non-Moro IP communities in the proposed Bangsamoro territories have to be considered as well. We also recommend that the youth be given a seat. There is a strong clamor from the youth that they be specified as a sector with a reserved seat to participate in the decision-making process, as it has been of great concern that they have been potential recruits for violent extremism. The manner of providing reserved seats would be understood as generally subject to the constitutional mandate that the members of the Legislative Assembly are elective without necessarily requiring direct elections and representative of constituent political units. It is often said that history is a guide to the future. The so-called Moro problem, or the Bangsamoro question, is a product of their painful and unfortunate colonial past. As the Filipino nation moves forward, healing the past and building the future, there is a need to educate ourselves, our communities, and one another that we are all victims of historical injustices. Understanding the history, culture, and identity of the Bangsamoro people will bring Filipinos closer to common goals of a peaceful and progressive society as a nation. After all, the Philippine society is a multicultural society, and education plays a major significant role in the transition program building process. In Section 13 of Article 9, it provides a very beautiful idea of what compared to the rest of the country. It was also pointed out that the prejudice and marginalization of Bangsamoro people is perpetuated by the lack of proper education that showcases their distinct culture and identity. Peace education was also recommended to be an integral part of the provision for the purpose of promoting a culture of peace and diversity in the Bangsamoro territories among all peoples in the region. The cluster also feels that Bangsamoro history, culture, and identity should be included in the curricula of educational institutions in the Bangsamoro and all throughout the country in order to eliminate any prejudice towards the Bangsamoro people. We recognize that there are provisions pertaining to non-Moro indigenous peoples across the BBL, but we also looked into a special of the non-Moro IPs since they have an ancestral domain claims with an area of at least 309,720 hectares encompassing 84 barangays in 8 municipalities now. Having reviewed its consultations, position papers, and focused group discussions with IP communities, we suggest that a separate article be devoted to the recognition, protection, and promotion of the non-Moro indigenous people's rights, such as are laid out in IPRA, or other mechanisms that will perform these functions until more appropriate solutions can be created by the Bangsamoro Parliament. We also consulted representatives from non-Moro indigenous peoples in the core area. We all know that this is a sensitive issue, and areas affected by the plebiscite. They were united. They were very strongly united in asserting that the following non-exclusive list of their rights under the IPRA also be included in the BBL. Specifically, these include but are not limited to fundamental human rights and development, identity and self-ascription, ancestral domains and lands, self-determination and self-governance, cultural integrity. In conclusion, upon various consultations and discussions, the Cluster on Social Justice and Human Development would like to emphasize and conclude that these provisions are due with a context on the historical injustice committed to both the Bangsamoro and non-Moro indigenous peoples, ensuring the improvement of the Bangsamoro and non-Moro indigenous peoples' socio-economic conditions will result to giving more hope that people in the communities can focus on ways to develop their socio-economic means through non-violent resolutions. Let us provide a social order to these injustices of the past that created the root cause of the armed rebellion that started the armed struggle. That summarizes the report on social justice and human development. Thank you so much. Wassalamu alaikum wa rahmatullahi wa barakatuh.
Thank you very much, by Rohanis Sumdad Usman, for that. We are very much in agreement you are very much in agreement with our opinion in the Senate that a great deal more needs to be done in the BBL to specify and define not only the rights of the IPs, but also the ancestral lands and, for that matter, ancestral domain, and what that definition will be within the framework of the Bangsamoro government. You clearly have paid a great deal of attention to that issue, and that is why we would like, the committee would like, if you have more detailed proposals to be made on the specific section, on the specific sections that are to do with the IPs and their ancestral lands and ancestral domain, which is what I believe their position has been. that they must be granted ancestral domain of of the lands that are defined as belonging to the indigenous peoples and the different tribes of the IPs. So thank you very much for that. I think Escudero has
Just
a
a
manifestation.
very brief interjection, Mr. Chairman. Ma'am, good morning. From the social justice perspective, not the constitutional perspective, I would not want to debate with the former Chief Justice. What do you think of the ministerial parliamentary form of government? Again, I'm approaching this from the social justice perspective. Meaning to say, ngayon, kayang iboto at patalsikin sa pwesto ng isang ARMM voter, governor. We will be taking that right away from him, the right to directly vote, if we adopt a parliamentary or ministerial form, because it is the members who will now choose the head minister. Again, from the social justice perspective, hindi ba mas maganda na yung sistema natin ngayon? People, the Bangsamoro people, can directly vote for the head or chief minister, voting indirectly through the for such a position. Ma'am, what do you think?
Coming from the civil society group sector as well, we actually have between the unitary and parliamentary form of government. And in terms of accountability, and isa naman po yun sa mga issues and concerns, especially with our people. And in terms of accountability, it would be more effective if sa parliamentary po tayo.
More effective in a parliamentary form? Accountability? you
That's
also have to
my own
remember,
opinion as well. But because that part of the discussion, it didn't rise in our discussion during the cluster. But what I'm giving to you now is my personal opinion, sir.
Ma'am, would that still be true even if only 40% of the parliament will be directly elected by the people? 50% will come from party list representatives not directly elected by the people. In other words, they will simply vote for party list groups, very much like what we have now, but it's limited to only 50, not 50%, and 10% will be sectoral representatives, presumably appointed and not elected. So in a parliament that 60% of which will be not directly elected by the people as well, only 40%, still you would entrust it to them. And remember, the Bangsamoro will have its own COMELEC, who will accredit party list groups, who will register kung sinong pwede at sinong hindi. I mentioned social justice because one of the cornerstones of peace in Mindanao should be that it should not be reserved to a particular or specific group. That the MNLF, the MILF, the BIF, the JM, or any other group or any other person from those groups a fair chance to win and govern and present his or her own platform. Hindi yung ARMM, nakareserba yan sa MNLF eh. Kaya naman siguro pumalagi ang MILF eh. Itong BBL, the last thing I want is for it to be reserved exclusively for the MILF. Na lang ang pwede mag-govern because the cards are stacked so much in their favor. And that is quite evident in the composition of the parliament right now. So, can you help us out as well? Again, not from the legal, but from the social justice perspective, to equalize it. To give each and every citizen, each and every person residing in the BBL to have a fair chance to actually run, win, once he is qualified, regardless of the group he belongs to, regardless of the tribe he belongs to, regardless of the province he hails from, so that it will be more long-lasting and we have a better chance at maintaining peace.
The fundamental question I think that we are confronted with is why the structure of the Bangsamoro government is parliamentary. Why in the first place do we not adopt what is already being exercised in the other local government units? Is this part of your attempt, or a part of an attempt to equalize, as you say, the inequalities that had been suffered by both Bangsamoro and non-Bangsamoro peoples in the South? And is that a cultural response? Does that come from the history of the Bangsamoro people? Is it grounded in the differences in our culture or religion? It is just something so as to give us a bit more clarity as to what is being attempted, what are we trying to achieve. Before you answer, ma'am, I would just like to acknowledge the arrival of the Most Reverend Orlando Cardinal Quevedo and Attorney Christian Monsod. Welcome to the Senate. Thank you. So, if with that acknowledgement, perhaps you could try and clarify those questions that we have raised.
Firstly, as far as the BBL is concerned, it explains the struggle of the Bangsamoro people, not just of the MILF nor the MNLF or any group, but this is the struggle of every of the Bangsamoro people. Secondly, when it comes to concerns in terms of humanitarian perspective, dalawa po ang kinikilala po ng Bangsamoro. Ito po yung tinatawag na federal system, form of government, and parliamentary. When we look into the Islamic perspective, meron po tayong tinatawag na, yung Professor Bajunait is also here, no? Coming from the ulama sector, na Islam is always chooses the path which is for the benefit of the ummah, which is for the benefit of the Islamic society. So when you talk about parliamentary, you are talking about yung boses po ng bawat sektor, regardless kung ito po ay ano-anong grupo, regardless rin po kung ito ay Muslim, Kristiyano at Katutubo. It is for it is para po ito sa to be answerable to the inequalities or injustices committed to the Bangsamoro people. So yun po ang aming paniniwala.
So we just needed that to give context, to give background, no, to that the proposal that the Bangsamoro government only because during all the deliberations and the constitutional amendments which proposed that we move to a parliamentary form of government, a unicameral form of government, it was made very clear by during public hearings and surveys and such that the Filipinos in general would prefer to vote directly, for example, for their president, and would rather be averse to the system wherein the parliamentary system, where we have the members of parliament choosing the prime minister, or in this case, the chief minister. And we are just trying to understand why there is that difference. So it is not to question the efficacy of a parliamentary system, but really just to understand how it will work. Because as you have mentioned, we are a unitarian republican system in the country, and that why there is that difference and where does it spring from. So, Father Tabore, you wanted to add something.
Thank you very much, Mr. Chair. I was not myself a part of the negotiating panel, so my suggestions are purely personal, based on my understanding of the situation in Muslim Mindanao. I presume that part of the option for the parliamentary form of government is simply because of the nature of Bangsamoro, which is not just one. The Bangsamoro consists of 13 ethno-linguistic groups outside of the non-Islamized indigenous groups in the areas, plus the Christians in the areas. And I think we also know that in the past, when we had the direct voting and the the problems we had with the structure of decision-making under a direct democracy in that the democracy to a great extent did not work. It was basically decided by feudal landlords, feudal lords who so I think consistent with the provision of the social justice of the Constitution that we must also diffuse political power. I think this option for a parliamentary form of government within the Bangsamoro, where power was monopolized, small groups, that there is more of a chance of a diffusion of political power through the parliamentary system. But that is an opinion. I defer here to the negotiations that have been conducted between the peace panel and within the peace panel. But that is my opinion.
Thank you, Father Tabora. He objects to my referral to him as my lolo cardinal. So my uncle cardinal Quevedo wanted to add something to the discussion.
Senator Marcos and Senator Escudero. My experience in Maguindanao is the following. During the time when we had a parliamentary form of government, I was president of Notre Dame University. And that from the Bangsamoro, the Moros of Maguindanao seem to have liked that parliamentary form of government because secondly, it has something to do, it corresponds a little bit to their culture. When I was NAMFREL, chairman a few years ago, I recommend the direct participation of people, one vote for every person. That seemed to work in Maguindanao. It has not worked since time immemorial. And I suggested that perhaps a council would do the selection of their leaders rather than direct voting, because it is part of what Father Tabora has said, the feudal culture, the role of datus and sultans in certain parts of Bangsamoro, but especially in Maguindanao. And so I thought that I would recommend in my report to NAMFREL the idea of democracy being practiced through the elections by council of elders. And I was, but that is not democratic. I said, that is very democratic. It is in Plato's Res Publica. It is in Plato's where voting was done by philosophers. So here, council of elders will choose their own leaders. I think that is part of the culture in that area.
But that is I don't know, but my initial reaction is that that is institutionalizing what we have identified. And that the problem that we have identified is that the tribal structure still seems to dominate even political exercises. And to have the Council of Elders would be, again, as I said, institutionalizing that whole system. And the opinion, I was of the impression that the reason that the parliamentary system was being proposed was specifically to and to spread the power centers around rather than to keep them within the tribal leadership. So again, this is where the conflict in a political structure arises. And again, that is why it is important. That's why we were asking by Rohanisa Usman, where this ideas, and it would help to clarify to help us to understand how this idea will originate, where it originated, going to be applied, and why we believe that it will be a better specifically for the Bangsamoro government. So, yes.
Your Honor, may I add?
Yes, of
just
course.
brief lang po. Let me also raise 2 points in terms of a humanitarian point of view and historical point of view. As far as the humanitarian point of view is concerned, sa system po natin ngayon, nakikita po naman natin, as mentioned by Father Tabora, power was really monopolized. Not just monopolized, but really controlled by political leaders who have their own personal interests. So ano po nangyari? It corrupted the system. It corrupted the minds of the people. Only that. Paulit-ulit na lang po ang electoral fraud natin. And isa sa mga corrupt, in terms of yung may corrupt practice, pagdating po sa eleksyon ay ang so, and yung mga tao po mas lalong naghihirap, bata every year inaako pa rin na historical injustice na napapasa from one generation to another. And in terms of historical point of view, you mentioned about tribes. Alala ko po, when my lolo, Sultan Asgarsani, was still alive, he told me, anak, since time immemorial, we already had the sultanate system. Pero ngayon, hindi na kami napapakinggan. Nung kami, when we were still implementing, when we still had the sultanate system, we were at peace with one another. Kapag po may problema sa komunidad, it's the datus, it's the within the local community, it's the council of our elders, the different kinds of conflict in the community. Maganda po yung practice na yon because having the council of elders, having a tribal council is very much effective because we know the cultural sensitivities. We know the practices as far as Islam is concerned. And ang nangyayari po kasi ngayon, if tomorrow implementing certain policies without the voice of every sector, without the voice of Muslim, nagkakaroon po ng problema on the ground. Insensitivities occur, and so on and so forth. So for us, having different voices can strengthen, having different voices can strengthen yung na po naming beliefs and practices as far as culture and tradition is concerned. And on the other hand also, subukan natin because ngayon hindi po nagkaroon po ng mga iba't ibang practices, corrupt practices every year na lang po. And this is worth a try in terms of electoral reform. And inshallah, God willing, it will work.
Thank you. Yes, Attorney Monsod also wanted to add something. Chief, after the attorney, because he has not had the chance to speak yet. Yes, Attorney Monsod, please.
Good afternoon, sir. Maybe I'd like to address myself to the very valid question of Senator Escudero about the social justice aspect of this. There are so many social justice provisions in our Constitution, as you know. They're not only in Article 13, but in numerous others. Like, for example, the term limits is a social justice measure. The party list system of proportional representation is a social justice. And the question is, does the indirect voting of a prime minister constitute an exception to the social justice system? And I believe the answer, sir, is that he is directly elected by the people. And if that is a structural problem, maybe, and we are addressing structural problems, the more important ones are we are so focused on a speedy and accurate count today that has already been devalued by 4 structural problems. The improper use of government money in elections, of money in general, in government money. Number 2 is, I hope I don't offend anybody, is the dysfunctional political parties who give the voters very limited choices in elections, so that their power to vote is limited to those chosen by political parties, mostly. Number 3 is the problem of warlords and loose firearms. And number 4 is the rise of political dynasties. These are more important structural problems that we are facing. And I would agree with you, sir, that the justice aspect of not being electing a prime minister directly. But we are proposing that the 2/3 vote to remove parliament be limited to the prime minister. So he is individually accountable to the people who voted for him through their elected representatives. So if you look at it from that point of view, Your Honor, it may not be too much a structural problem on the prime minister, sir. Thank you.
Chief, you wanted to add something, after which
Yes, a
I
little
would like just to
contribution,
move on to the
Your
last
Honor.
cluster. Yes, Chief, you have the floor.
I think it is now an accepted concept that a parliamentary form of government is the most responsive and responsible and accountable. It's because of the structure. So it's a global phenomenon known, as a matter of fact, that more countries are adopting the parliamentary form of government. Because for a unitary system, the presidential system, much objections have been raised because of the slow growth probably in the delivery of equality or equalization. And the provision now on the Bangsamoro Parliament, especially the classification and allocation of seats, the election for reserved indigenous peoples would clearly show that the idea really, the marginalized sector of the Bangsamoro area to have a say in the parliament. Look at the reserve for the non-Moro indigenous peoples. There was an objection that probably it might not even be very democratic in the sense that you cannot directly elect the chief minister. And that is the idea really in a parliamentary form of government. There is some sort of infusion between the executive and the legislative to promote precisely accountability and accountability. But what we added here, really, what we suggested is in the so-called no vote of confidence. Because originally, when there is a vote of confidence, the chief minister must at once dissolve the parliament. So it would therefore destroy the synchronization of elections under the Constitution. So we propose that the no vote of confidence would only affect the government, but not the parliament. The parliament will stay in the meantime. So the people are really represented. The chief minister cannot just simply continue his supremacy in the area. I think what should be done in order really to have some equalization and to give more meaning to social justice in the matter of the parliament is to add the number of reserved seats for the non-indigenous or for others. For women, women shall also have a reserved seat. Probably you could increase the number of seats for women, and that is equalizing the population within. So I would suppose that when this was contemplated, it had in mind the best interest of the Bangsamoro to see to it that you really would give meaning and significance to the concept of equality in the political structure.
Mr. Chairman, if I may, a brief rejoinder before you continue.
Go ahead, please.
Thank you, Mr. Chairman. Working with the panel, of course, I raised the concern basically under the concept that, again, sa ngayon, binoboto ng mga tiga-ARMM, future Bangsamoro, yung head of government nila. Going on since 1996. Kung may dayaan man o wala, may barilan man o may tutukan, may bilihan, I mean, they're voting directly for the head of government of the ARMM. After we pass this, they can no longer do. Now you say there is a council of elders, the Datu system, but the council of elders and the sultans are all determined by the accident of birth. Pinanganak silang sultan anak ng sultan, apo ng sultan, anak ng Datu. Paano ho yung hindi? Wala ba siyang karapatan na pamunuan pagdating ng panahon? Ang may karapatan lang bang pakinggan, sundin? I know it's cultural, but again, hindi naman lahat na maganda limitado lang sa mga Datu at sultan May hindi Datu at sultan na maganda ang plano at vision at intensyon para sa BBL. And we cannot take that right away from him. And I would not want to take that right away from him. Pinag-usapan natin yung parliament, sila pipili. Sige po. But I don't think it should be 50% party list and only 10% sectoral, as you said too. In the current computation, sir, 80 members of parliament yan. Because there are 32 district representatives. If it is equivalent to 40%, then you have 40 party list representatives and 8 sectoral representatives. That's how the parliament. Do you honestly think, sir, that they can choose a leader that best represents the entire membership of the BBL? Meaning everyone. Ngayon pa lang ho sa gusto magpa-abolish ng party list system. I mean, instead of learning from history, we're repeating the same mistakes of history and doing it all over again here. It sounds good that the party list system will give representation to the various sectors. But looking at Congress, ni isa ho ba may mangingisda doon? May ni isa bang tunay na magsasaka na talagang nagsasaka ng lupa na miyembro ng Kongreso ngayon? We haven't seen that for the longest time. In fact, the party list group has been a mechanism for families to enter Congress instead of through the district system. So I have no strong objections really legal as of yet on having a parliamentary form, but I want it to be more democratic, more fair, more open to the ability of a person born not as a Datu or Sultan to serve the BBL, to be a part of it, to be a part of molding it, shaping it, and making it a better place to live in, and not simply limited to those that, meaning a sultan, a Datu, or relative, by the accident of birth. Hindi naman hula tayo maswerteng ganun Mas marami actually ang hindi So, whether by increasing sectoral representatives, increasing district representatives, reducing party list groups, or defining and really clarifying, learning from the mistakes of the past, nitong party list system, kung sino lang ba talaga pwede maging party list group. Remember before, we have to learn from the mistakes of the past and hopefully make the parliamentary system more vibrant, democratic, and reflective of the sentiments of the people for it to be truly representative of the sentiments.
And I would like to say that his views on the BBL as a lawyer and a soldier have enriched discussions in this cluster. I am not a lawyer. And actually, I am not even the president of the Asian Institute of Management anymore. For the record, Mr. Chairman, I stepped down in 2012, and although I have stayed in the faculty as Professor Emeritus. So I must begin by placing this report in context. First of all, the output of the cluster, as indeed the output of the entire piece, is the product of a collaborative effort. I hope the committee will find reassuring that the security cluster benefited from the counsel given by 6 retired generals. Second, from the diversity of our individual experiences, we came together to understand the proposed BBL. As individuals, we had our own views on priority issues and different preferences on the language to express these views. But we focused on what we considered the contentious issues and reached consensus collectively could support. Third, even as we recommend our conclusions, we recognize that the legislature must bear the responsibility of passing the BBL. The Peace Council is a private civil society effort to promote the peace process by helping to clarify the complex issues of the BBL. The House of Representatives stressed that it wanted to pass an effective law, one that substantially addressed the problems of the region, but also one that could be properly enforced. We assured the body that we also shared this objective. Senate President Dillon stated that the BBL law must be constitutional, fair, and inclusive. And we affirm that we also regard these as essential criteria without which the law would not be effective. Recognizing the importance of the BBL to the entire country, we come to the Senate in the spirit of seeking to make a contribution towards understanding what would be required to make the law more effective. It is crucial to establish this as the premise of our deliberations on the issue of security, which for a number of reasons has become arguably the most sensitive of the themes addressed by the Council. First, while failures in the other clusters can lead to difficult legal cases or heavy financial losses, mistakes on security issues can immediately lead to the massive displacement of communities and the loss of lives. Second, security issues we face in the Bangsamoro region already embraces an international dimension. We have the engagement of Malaysia, the Organization of the Islamic Conference, an international monitoring team, as well as the United States and its current and potential allies in the global war on terror. Ending the violence in Mindanao is no longer simply a national concern. The factor that made security a sensitive issue is, of course, the Mama Sapano incident. Observers have commented that without Mama Sapano, the BBL deliberations would have proceeded with less friction and less heat. For the cluster to avoid addressing Mama Sapano would have been to ignore the elephant in the room that was sucking up all the oxygen. Thus, the cluster focused on 3 areas of concern. First, the issue of trust, which is critical to the peace process and has been undermined by Mama Sapano. Second, provisions in the BBL pertaining to public order and safety, Article 11, and the normalization process. And third, broader issues of peace. On the issue of trust, we must recognize, in fairness, that both parties in the peace process, the government and the MILF, felt a betrayal of trust. Difficult as it is, both sides must distance the issue from the grief and the anger provoked by the casualties they suffered at Mama Sapano. The cluster acknowledged the supreme sacrifice that the SAF troopers made in giving up their lives in the line of duty. We owe them honor and their survivors assistance. But we must also place this incident in context and in perspective. Mama Sapano was not a suicide mission. We are not talking international terrorists. Nor, some of you may remember, Tennyson's Charge of the Light Brigade. Mama Sapano was not that either, where 600 light cavalry of the British attacked entrenched artillery positions. They knew what they were getting into, but they attacked nonetheless because the order had been given. The SAF troopers attacked in the dead of night, in the early morning actually, with proper planning. And as it turns out, not all of the 300 sent out to Mapasapano actually were engaged in the combat. So, even as we recognize the heroism of those who died, we cannot overlook the failures in planning, leadership, and discipline in the conduct of the operation that had already been noted in official reports. But again, I say, those failures do not diminish the dead and our duty to make sure they are properly remembered. Similarly, while acknowledging the failure of the PNP to undertake proper coordination with the MILF, the MILF must also account for whatever failures in discipline and whatever crimes their men might have committed during the firefight in violation of Philippine and international humanitarian laws. The cluster concluded that the full resolution of the Mamasapano incident should not become a precondition for pursuing the peace process. By its nature, conflict breeds mistrust, which Mamasapano has unfortunately intensified. Conflict resolution requires willingness to hope. To conclude a peace agreement, parties to the conflict must be willing to suspend mistrust long enough to make relations productive. The real work of peacemaking is reconciliation and justice. And that comes after the agreement, not before. Signing peace agreements does not by itself ensure peace, but it makes possible the reduction of violence and creates the space for reconciliation. The cluster therefore believes that the best way to rebuild trust is to pursue the peace process and the passage of the BBL, even as the task of evaluating the failures of Mamasapano continues. Because Mamasapano did reveal fundamental security gaps and raise crucial questions about how government manages peace and security, including the coordination of the AFP and the PNP. Resolving questions about Mamasapano, and indeed about all the incidents of injustice during the decades-long insurgency, may need to go beyond ordinary penal laws. A criminal code copes poorly with the complex questions that arise from the extraordinary circumstances of armed conflict. Nor can it deal with deep-seated grievances and intergenerational prejudice. But a peace agreement is necessary to end violence and bring contending parties to a common legal regime that can address justice. Once the BBL is passed, these important questions can be brought under a civic or even legal regime established within the BBL or through other related institutional mechanisms. The security cluster saw the BBL and the peace agreement as the foundation upon which the long-term work of reconciliation and justice. The second issue the cluster explored was the security threat of secession. Some sectors have claimed that the BBL contains no commitment or assurance that the MILF or the Bangsamoro government will not secede from the Republic in the future. In the first place, the peace process could not have progressed if the MILF had not agreed to accept autonomy instead of pressing for independence as a separate Islamic state. The BBL itself, once passed, is the assurance that the MILF has set aside its drive for secession. Signing the government for autonomy integrates the MILF and the Bangsamoro into the Republic. The engagement of foreign countries in the peace process makes them witnesses to the fact that secession is outside the scope and the intent of the BBL. The support of the international community for the framework of a peace process anchored on the Constitution and the sovereignty and territorial integrity of the Republic would weaken any support for international recognition of Bangsamoro as an independent state. Whether secession remains a threat, feeling disadvantaged, Catalonia has expressed the wish to secede from Spain and Scotland from the United Kingdom. If the Bangsamoro community, even while autonomous, continues to find itself exploited and victimized by an abusive national government, then succeeding Bangsamoro generations may well revive the call for secession. In truth, there is no silver bullet, as there is no silver bullet that will erase all sources of violence. There is no magic vaccine that will inoculate the country from the problems of future misgovernance by corrupt or intruders. In the meantime, the strategy against secession is the passage of the BBL and its effective implementation to provide a national environment that allows the Bangsamoro Autonomous Region to develop as part of a diverse Philippines. And we must work together to ensure that we give them no reason for secession. The cluster also identifies some specific provisions of the BBL. On the creation of a Bangsamoro Command of the AFP, the provision in Article 11, Public Order and Safety, Section 15, has been wrongly interpreted as permitting the Bangsamoro government to organize its own army. But the Bangsamoro Command, if and when it is organized, will be established by the national government, not by the Bangsamoro government. It will remain under the AFP Chief of Staff, and it will be similar to existing commands in Mindanao, such as West Mincom, Western Mindanao. On the Bangsamoro Police, Article 11, Section 2 explicitly states that the Bangsamoro Police shall be part of the Philippine National Police. This has not ended speculation that the police may grow into a separate armed force. A police, quote, shall be part of the Philippine National Police in accordance with Chapter 3 of the DILG Act of 1980, Republic Act 6975, as amended, close quote. This additional clause will guide the Bangsamoro Assembly when it legislates the law that will govern the Bangsamoro Police. On normalization and decommissioning of the MILF, critics have expressed concern over the lack of a clear and time frame for decommissioning. The phasing of the decommissioning of the MILF's armed forces has been tied to milestones in the implementation of the peace agreement. For instance, upon the creation of the Bangsamoro Transition Authority, the MILF will decommission 35% of their forces and weapons. This is the approach followed in other agreements abroad between governments and insurgent forces. The surrender of the means of self-defense is not a step taken lightly by insurgent forces. The MILF also needs the assurance that the government will keep its end of the peace bargain. Moreover, the MILF also confronts threats from other armed groups in the region that the national government has not been able to control. If we wish to accelerate the decommissioning process, therefore, we should quickly pass the BBL, which is required for the creation of the Bangsamoro Transition Authority, a milestone for decommissioning. Transitional justice, a comprehensive solution on peace and security. The BBL currently refers to the creation of a transitional justice mechanism that addresses, quote, the legitimate grievances of the Bangsamoro people, such as historical injustices, human rights violations, marginalization through unjust dispossession of their territorial and proprietary rights, and customary land tenure. The current Transitional Justice and Reconciliation Commission has already begun addressing some of these issues. The creation of a stronger justice mechanism may give an opportunity to ensure that full measure is given to address grievances beyond Mamasapano and beyond land disputes with impartiality and sensitivity. The BBL itself may be the instrument for expanding the TJRC, although a separate body may also be established. We need to empower and institute will have enough time and resources to understand and reconcile the overlapping claims of the Penal Code, international humanitarian law, the laws of war, and the campaign against terrorism. Transition aims at both conflict resolution and conflict prevention. It should include the task of crafting the Philippine narrative of its internal conflicts. We must strive to ensure that it is a shared and inclusive narrative, however imperfect the initial draft may be. Many of us have been far removed and detached from a conflict that has affected generations of our fellow Filipinos. We are as likely to repeat the failures of peacemaking as our predecessors if we remain ignorant of this conflict context. A country of great cultural diversity, the Philippines needs a shared and inclusive historical narrative. The resolution of the separatist insurgency in Mindanao offers us a chance in this crafting. The ultimate purpose of transitional justice goes beyond ending violence and administering punishment. The objective is reconciliation and healing to end the cycle of deprivation and destitution, the tragedy and the horror that conflict brings. To borrow Argentina's battle cry against oppression, nunca más, never again. We hope the Senate will lend its voice to the country's cry for peace. Thank you very much.
Thank you, Secretary De Jesus. And that brings us to the end of the presentations and beyond, in fact, our allotted time. So we will have to bring this hearing to an end for now. Certainly the presentations that were given us this morning and this afternoon, we will be providing copies to the other senators. I would just like to make a quick inquiry. Is the Peace Council now dissolved after you have written your final report, Chief Justice Davide?
Honor.
Is the Peace Council now dissolved, or is it still even after you have given your final report to both houses? I only ask simply because there may be requests for questions to be propounded to the members of the Peace Council after today.
We would consider that a rare honor.
Thank you very much. That gives us the opportunity to go into more of the questions that we were beginning to cover in some of the comments that were made by Senator Escudero and myself. So I thank you all very, very much. It has been helpful and useful. A helpful and useful exchange, and we are privileged, I will say once again, to have individuals of such stature bringing their views and suggestions to the committee. So I thank you very much for that. And if there is nothing else, we are adjourned. Thank you very much. Secretary,
With your Mr. Chairman, may I just address the first question that the Honorable Senator Escudero raised in the first intervention. I cannot speak for the MILF because we don't have any opportunity to invite any of them to our meetings. But I think the OPAP meeting panel may have not succeeded in expressing their views on the BBL because we did have an opportunity. We did have an opportunity to meet with them, and for instance, clearly admitted that there are certain areas that needed clarification, and he was hoping that these clarifications will be made in the course of the legislative process. Thank you very much, Your Honor.
Mr. Chairman, just a brief rejoinder on that. I completely agree, sir, but again, you're kinder than I may possibly be. They were simply unsuccessful in imparting that message and giving us a hard time, parang sa negosasyon, di ba? Aim high, shoot low. Perhaps getting to yes, getting past no, that you should start. But that's not how it should be. As you said earlier, sir, distance, mamasapano, and that is a very sensitive issue. But government is not helping any also. MILF ang pumatay sa SA 44, sasabihin ng OPAP at GRP, it's a different issue. Hindi MILF ang pumatay kay Usman, but government will say, thank you, MILF. I don't get it. Di ba? Yung pinatay nila, hindi sila may kasalanan, yung hindi sila pumatay, papasalamatan natin sa terrorists, then they should not also connect that if we will not be connecting this. And as a last, fine, the MILF and the GRP have developed trust in the court that they have been talking. But they should win over the trust of the Senate as well, of Congress, and most importantly, of the people. And they have not been able to do that with their stance, with how they have been speaking. I welcome the creation of the peace panel because you are more level-headed, reasonable, rational, reconciliatory, and actually speak with a more reconciliatory tone than anyone who ever faced us in the course of our deliberations in connection with the BBL, and with an open mind, na hindi yung sagrado at sarado na lamang. And as a last point, Mr. Chairman, we have been discussing in the Senate from day one, bakit ba hindi na lang amyendahan natin yung ARMM? Bakit ba kailangan panibago na naman? O kung babaguhin nyo, hindi sabihin natin Bangsamoro Autonomous Region, BAR, instead of ARMM. It will convey clear messages and allay a lot of fears too. Ang tanging sagot na nakuha po namin mula sa OPAP at GRP, it's a political statement. Well, political statements belong in speeches, not in laws. Finally, as a final point, Mr. Chairman, sir, the MLF killed the SA 44 because they did not coordinate. That's the long and short of it, according to the report. Now, the word coordinate, coordinated, and coordinative appears 26 times in the BBL. Kung ngayon pa lang po, hindi pa batas, nagiging dahilan yon. Ano pa kaya kung batas? So all the more reason that we should be able to clarify and remove any doubt with respect to the meaning of the words used in the BBL. Because each and every word used here would have a legal meaning, not only a political meaning. Yung political meaning, they should explain that to their counterparts. We only deal with the legal effect and meaning of the words and provisions used in the BBL. We look forward, sir, to working with each and every one of you in each of the clusters. And I think it would be easier to work with you in crafting a more meaningful BBL, sir, in coordination also with the OPAP, MILF, and GRP.
Thank you,
Thank you po.
Senator,
Magandang
Senator
hapon.
Escudero. This has been our experience that both in and out of formal hearings, the pronouncements of OPAP and MILF, and again the executive have been rather strident. If you remember, we began at the point of rather no BBL than a mulled BBL was the statement. We are gratified and encouraged to hear a different tone from the Peace Council, and I think that you have the Peace Council in that regard has certainly moved the process forward, and for that, once again, we thank you. So, and on that note, we are adjourned, ladies and gentlemen. Thank you very much.